When people hear the phrase majority shareholder, they tend to imagine a corporate emperor, a person sitting at the head of a giant table, pressing buttons, firing directors, approving deals, and generally behaving like the final boss of a business textbook. And to be fair, majority shareholders do have significant power. Usually, if you own more than 50% of the shares in a company, you can control certain voting decisions. You can appoint directors, remove directors, approve certain resolutions, and steer the overall direction of the business. So yes, majority shareholders hold the steering wheel. But, and this is the important bit, they do not own the road, because company law places limits on what majority shareholders can do, particularly when their actions unfairly harm minority shareholders. And that brings us to one of the most important concepts in shareholder disputes, the minority shareholder prejudice claim, which sounds slightly less exciting than it actually is. Now imagine you own 20% of a successful company. You helped build it, you invested money, you worked long hours, you tolerated meetings that absolutely should have been emails. Then one day, the majority shareholders start excluding you from decisions. You stop receiving financial information, you are removed as a director, your salary disappears, and strangely, the company suddenly starts paying the majority shareholder's cousin consultancy fees for reasons nobody fully understands. At that point, the majority shareholder may believe they can simply outvote you forever. But this is where the law steps in and says, not so fast. Under the laws of England and Wales, minority shareholders can bring what is known as an unfair prejudice petition. In simple terms, this is a claim arguing that the company's affairs are being conducted in a way that unfairly prejudices the interests of minority shareholders. That phrase sounds very legal because, well, it is. But the principle itself is fairly straightforward. If majority shareholders abuse their power in a way that is unfair, the court can intervene. And importantly, unfairness is not limited to obvious fraud or dramatic misconduct. Sometimes it is much subtler. For example, freezing a shareholder out of management when everyone originally understood they would be involved in running the business, or refusing to provide company accounts, or paying excessive salaries to majority shareholders instead of distributing profits fairly, or changing company's constitution in favor of the majority shareholders, which is the corporate equivalent of moving the goalposts halfway through the match and then pretending that was always the plan. Now, majority shareholders often assume that because they technically can pass a vote, that automatically makes their actions lawful. It does not. The law distinguishes between legal control and unfair conduct. That is a very important difference, because courts are not particularly impressed by the argument, yes, my lord, we excluded him completely, but technically we did win the vote. In many smaller private companies, especially family businesses or founder-led businesses, the courts recognize that relationships matter. There is often an expectation of trust, participation, and mutual involvement. So when majority shareholders suddenly behave as though minority shareholders are merely decorative accessories, problems tend to arise. And the consequences can be serious. If a minority shareholder succeeds in an unfair prejudice claim, the court has wide powers. For example, the court may order the majority shareholders or the company itself to buy out the minority shareholders' shares at a fair value, which can become very expensive, particularly if the majority shareholders spent several years insisting the minority shareholder contributed absolutely nothing of value whatsoever. And importantly, litigation of this type is rarely cheap, quick, or enjoyable. Shareholder disputes have a unique ability to combine legal complexity, financial stress, and deeply personal resentment into one very expensive package. It is essentially a group project with barristers. So, do majority shareholders have power? Absolutely. Do they have unlimited power? Definitely not. The key lesson is this. Majority control does not give shareholders permission to behave unfairly toward minority shareholders. Because while minority shareholders may not control the votes, they often possess something equally powerful, a legal remedy. And sometimes that remedy becomes extremely persuasive the moment solicitors start sending letters with phrases like breach of fiduciary duty and unfair prejudice, which coincidentally is when everyone suddenly becomes much more interested in negotiating sensibly. Funny how that happens. So, if you are a majority shareholder, the safest approach is not simply asking, can we do this? It is also asking, should we do this? Because winning the vote is one thing. Explaining your conduct to court is something else entirely. And unlike company meetings, judges tend to insist people answer the difficult questions. If you enjoyed this video, make sure you subscribe for more straight-talking insights into shareholder disputes, company law, and the kinds of business arguments that start with, "It's nothing personal," and usually end with a 12,000-page disclosure exercise. There are more videos coming on director duties, shareholder agreements, business breakups, and the legal disasters people accidentally create by copying things they found on Google at 1 a.m. So hit subscribe, turn on notifications, and stay tuned, because in business, the paperwork is never quite as boring as people pretend it is.